They're saying Herbert Kane, 24 DCCR 1083.
We were in county court too the other day, and it took literally 20 minutes to come up with literally 20 minutes. And I was doing rejection. He tried to, I believe it, I'm gonna get on Zoom and beat you. So I approached it after that plea. I said, by the way, Judge, Mr. Ross is on Zoom. He called his office to get on Zoom.
That's funny.
And he hit with another.
All right, sir. Are you Herbert Kane? Is your name Herbert Kane? And I'm going to take.
Okay, now here's where it gets serious. The judge is taking judicial notice, meaning she's officially recognizing prior evaluations in court without needing more proof. Translation: this guy's been tested, and the doc says he's fit to face trial. No more "I am not mentally stable" defense. The courtroom just leveled up.
Take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
There you go.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years in prison.
To 220 years. Let that sink in. The sentence range is wide, and that usually means one thing: the prosecution has wiggle room and the defense better bring its A game. Think this is too harsh? Let me know in the comments. Would you take this to trial?
Do you understand what could happen if you go to trial and you're found guilty?
I understand, but can I ask you a question?
Sure.
I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing. What happened surrounding this offense or what they charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for. And we can.
This is the classic crossroads moment. Plea deal or jury trial. The judge is not pushing him either way, but she's clearly laying out the land. And notice how calm she stays even when the defendant keeps circling back to irrelevant details. Patience of a saint.
Let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide two things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get
Here's the thing. Well, here's the thing. The offer is I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
And Your Honor, I've discussed these facts that concerns he's had with Mr. Nichols and explained to him the situation after he's had evaluated again to talk to about the offer. And Mr. Nichols has remained steadfast on the offer that he's made previously, which is the offer today.
Okay.
Just so that you're aware, it's not his first offense. He was actually.
And here comes the plot twist. Not his first offense. So much for the first-time offender sympathy angle. The defense just lost one of its strongest emotional cards. You could feel the shift in the room, right?
Before you did 2018.
Okay.
So they think
Burglary of a building, it sounds like.
for the state jail felony was
Mm-hmm.
it was dismissed.
I've gone over it.
Okay. So it doesn't appear that it was dismissed, but I just want to make sure right now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case as far as what she says about
Look, Regardless of that, that doesn't change even if you had it, it doesn't change the punishment in this one. Okay. That can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Might I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what,
It was sorry.
Go ahead.
It was a felony conviction with county jail time, so he may misunderstand that he is already a convicted felon.
okay. So it sounds like you got a 1244, which means you got a state jail felony conviction, but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks like.
So that,
So, here's where legal confusion meets cold hard facts. He thought the case was dismissed, but the paperwork says otherwise. Ever heard of a 1244A? That's when someone is convicted of a felony but serves time in county jail, not state prison. Sounds lighter, but it's still a conviction. Still on your record. Still changes everything.
1244A.
Mhm.
Okay, but from what I understood, it got dismissed.
It doesn't get, it did not get dismissed.
So 1244A is not reduced.
It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you.
That's what I'm saying.
It's a state jail felony conviction. But we're going to stop talking about that because it doesn't matter right now.
I was tipping and find out because I ended up going to Judge Woods for like.
That's misdemeanor court.
Exactly, for the reduction of.
Listen, it doesn't matter. Whatever that prior is or is not, does not matter on this case right now. This case that you're charged with, 2nd-degree felony, assault on a peace officer. The district attorney's office has made an offer of 5 years. Take it or go to trial. The prior is not what is enhancing you. It's not changing this. The offer is what the offer is. Do you want it or do you want to let a jury decide?
How much that time?
Well-
How much time I actually have to do?
I've discussed that with him this morning. Judge
Okay.
has approximately 100 days.
So
credit
hang
for
on a
time in
second.
jail.
You're asking me questions that your attorney has already gone over. Listen,
I didn't get
don't
that
talk
day.
up-
I was attempting
don't talk over me.
for school, so
Listen.
I'm trying to figure out.
Listen and don't talk for a minute because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence.
And there it is, the final hammer. 5 years, no guessing games, no confusion. But how much of that will he actually serve? Depends on his behavior, in prison, parole, eligibility, and a whole mess of variables. Risky roll. Of the dice, if you ask me, but what would you do in his shoes?
You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just